Hi, I'm Femi Oke.
And I'm Malika Bilal, and you're in the stream. Today, the U.S. Indian Child Welfare Act. Whose welfare is it protecting?
This issue has gone viral because of the emotional custody battle for Lexi, a 6-year-old citizen of the Choctaw Indian tribe, and it has gripped members of the Stream's online community.
Marty Simmons, an Indigenous activist, pitched us this show. She told us there is a major group out there who is wanting to dismantle ICWA, the Indian Child Welfare Act. If you could help get the word out, our children need safety and a voice.
So that's one side of the story, and we will look at some others. But first, if you have a story idea, you can share it with us really easily by tweeting #AJStream.
Film her. It's illegal to film her. Please stop. I love you. I love you. Right now. Violating the law. She's a foster child. I love you, Lexi. Can you tell us why you're taking her? They fought for you, Lexi. They fought for you, Lexi. They fought for you.
Dramatic images there of social workers taking a young citizen of the Choctaw Indian tribe from her white foster family has sparked an online storm to bring Lexi home. Lexi had lived with her foster family in California for 4 years before being transferred to extended family in Utah. The courts decided that Lexi should be with her extended family based in part on the Indian Child Welfare Act. But supporters of the foster family say that US federal law puts race ahead of the child's well-being. Malika.
Well, one of the biggest questions online from those watching this case is why the Indian Child Welfare Act exists at all. Well, those in favor of the law say it's important to know the history of how frequently Native children were taken from their homes before it was passed in 1978. And taking Indigenous children from their families has a long history outside of the United States as well. Countries like Canada and Australia have in recent years issued apologies for the practice, as you see here.
So with us to discuss the situation here in the United States, in Phoenix, Arizona, Chrissi Nimmo is the Assistant Attorney General of the Cherokee Nation. And in the studio, we have Adam Pertman. He's the President of the National Center on Adoption and Permanency. And Lori Alvino McGill is a lawyer representing the foster family, challenging the Indian Child Welfare Act known as ICWA. Good to have you here, everybody. Adam, I mean, a few decades ago, you could have seen that situation with little Lexi in reverse. So a child from a Native American family being taken away and placed with a foster family outside of their culture, outside of their tribe. Where are we now with that situation? What's happening?
Well, what's happened is we see, first of all, I think it's really important to say that whether you support ICWA or do not support ICWA, this is man bites dog. This is a story because it doesn't happen a lot, mercifully. So what's happening now is that people are arguing the merits of the letter of the law, because that's what's being followed in this case, is the letter of the law. Adults getting to sue each other, getting to go to court, getting to get stays, and in the meantime, over the course of almost 5 years, a child being, you know, the pawn in the game, if you will.
Sure.
The intent is to serve the best interests of the child. My view, from a child welfare perspective, is we've been doing a lot of serving the interests of the adults on all sides.
See, Lori, there's history here. Do you respect that history?
Of course. And I think it's a little strange that this particular case has served as the springboard for the much broader discussion about the merits of ICWA as a policy and as a law more generally, because as Adam pointed out, this is in some ways, I think, an aberration of a case. It's not a case where the purposes, the underlying really animating terrible things that resulted in the need for ICWA in the first place are really implicated. It's not a situation where anybody is arguing that the child was wrongfully removed from her biological parents. It's a child who is in need of a home, unfortunately, outside of her parents. And at the time that she needed a placement, she was placed with the tribe's consent, with the Page family.
You know, I hear what you're saying, Lori, but I will say people online are doing just that. They're talking about the merits of ICWA
Right.
as how they see it pertaining to cases today. I want to share just two personal experiences. Chrissy, this is one person called Mari. She says, I support ICWA because my mother was taken from her reservation family and placed with an abusive family, she says, before that law existed. Another person, this is Baldi, she says, ICWA is essential. I have cousins taken before ICWA, and they were told their families didn't want them. ICWA would have reunited them. So we see the history and the importance of it there, Chrissy. Do you still see that implication holding till today?
Absolutely. And adult adoptees are one of the biggest supporters of the Indian Child Welfare Act because they are the people who directly experience this. But we still today see a disproportional amount of Indian children in custody. An Indian child is 3 times more likely to be taken into custody than a non-Indian child. So although we have made progress in this area, the Indian Child Welfare Act is still needed, and Indian children are still being taken from their family. There's another case going on right now in South Dakota, a federal civil rights case where the state courts there were found to have violated the civil rights of the parents of Indian children by giving them 20-second hearings when their children were removed by social services.
Why does this happen, Chrissy?
I think that it is a result of this country's attitude towards Native tribes. The federal position of the United States was to destroy Indian tribes. And when you have 200 years of that history, you still have people that have those inherent biases that they think that tribal communities aren't able to take care of their own children, and tribal Indian parents aren't able to take care of their own children. They think that, such in this case, that this child would be better off with a non-relative, non-Indian family than placed with her own family.
Adam.
Hi there.
Yeah. Sticky question, right?
Well, it's a sticky question that interestingly doesn't apply to just Indian children. Children of color are disproportionately
Absolutely.
represented in the foster care system.
Yeah.
They are removed without judgment of the individual cases, because most kids are in that system because they're abused or neglected, and we need to protect those children. But the fact is that race appears to be a factor.
Right.
That on the face of it, children of color are removed disproportionately at greater rates than white kids from the suburbs who might be abused or neglected. So I think this is a more pervasive issue, and I think a lot of the issues that we're discussing here really have broader lenses that we can apply to them as well.
Sure. So, Laurie, if you're fighting a case in favour of the Page family, you saw their little foster daughter being removed in very dramatic circumstances just a few minutes ago on our show. Are you not part of the problem?
Am I not part of the problem? In what way? I mean, I'm not dodging your question.
Because Chrissy points out how many Native American children are still removed from their families.
Right.
Adam points out not just Native American children, but children of color.
Right.
You are fighting a law that was put into place to help keep Indigenous families, Native American families, together or in their culture or in their tribe. Are you not part of the problem?
I don't think I'm part of the problem. I think part of the problem is not the law necessarily itself. It's the way it's being implemented in this particular case. And we started out the show, or maybe it was pre-show, I made the comment that I think that this case in a lot of ways doesn't really implicate the underlying concerns that drove the passage of the act. And I think that whatever you think about the role of preserving culture and racial identity and other things, they're not sort of implicated in this particular case. She's being removed from a foster mother who has Native heritage to be placed with extended relatives who have no Native heritage. So if culture were the driving concern in this particular case, it's a very, very odd result. But my bottom line is that
I think we have to address the Native heritage of the foster mother. That is alleged Native heritage. Lexi is an enrolled citizen of the Choctaw Nation. Many people in this country allege that they have Native American heritage, but they're not legally protected as Indians under federal law.
That's true. She doesn't have legal status, but if I was addressing a broader question about culture, it's not just about one's legal status. I assume that if a child is Black and raised in a particular culture and then had to be removed from his or her family for whatever reason, we would, all other things being equal, probably look for a cultural match for that child in the best circumstances. So just setting aside the fact that they're federally recognized tribes are sovereign nations, and that raises a whole different set of issues. Just looking at the cultural and racial issues, they're not really implicated in this case. This child was taken from a family that was sort of a racial and cultural match to her, and is being placed at great expense to her own emotional welfare years down the line with a family that can't provide her that.
There is someone here that agrees with you, and Chrissi, I'll pivot to you, but there is someone here that agrees with Lori. This is via Facebook comment from Mary Jane. She says, we have to keep in mind that ICWA is not under attack, she puts in quotes. Its application being wrongfully applied, however, is. What's happening here is totally outside the scope of its intent. But what I want to throw you, Chrissi, is a question we got from Twitter. This is someone who says, we need ICWA because the state and Supreme Court still say child is only so much native. And we see news reports that say that she's 1/64th. So this person is asking, so does culture and family not matter? What role does that play in the 1/64th, the part native or fully native? What role does that play in this?
Well, I would first like to address that issue, the difference between race and sovereign nations, as Ms. McGill said. ICWA doesn't apply because Lexi is 1/64th Choctaw. ICWA applies because Lexi is a citizen of the Choctaw Nation. My race, if you ask everyone viewing today, they would probably say that I'm Caucasian, but I'm an enrolled citizen of the Cherokee Nation. My children are Indian children. It matters because they're government, and governments have the right, just like state and federal governments, to have a say in what happens to their children. And to say that this is race-based or that Lexi was removed because she's 1/64th Indian is just false. And what ICWA is doing in this case, I think more importantly than protecting her ties to her tribe, is protecting her ties to her family. ICWA is designed first to prevent the breakup of families. Second, if a child can't be in their own family, keep them within their own tribe. In this case, Lexi's being placed with her family. They're non-Indian family. ICWA doesn't distinguish between Indian and non-Indian family. The first placement preference for all Indian children is family placement, just like the first preference for any child taken into custody in this country is family placement.
So this is a sensitive issue, Adam. The idea that if you're part of a tribe, part of a culture, that you want your young people in that tribe, in that culture, to stay within that culture. How much is that factored in to the fostering process, the placement process?
Well, as it was just pointed out, in best practice, it's not always written down. Best practice in intercountry adoption as well as domestic adoption is, generally speaking, because every case is individual, every case has its own circumstances, but generally speaking, you want to keep a kid within the family, and if not within the family, then within the community, and if not within the community, then in intercountry adoption, then within the nation. And then if not, then maybe a family, another child in another country. Every child needs permanency. Every child needs a family. So better to have a family than not. But there is a sort of sometimes formal in intercountry adoption by treaty, and sometimes more informal. There is this hierarchy, this sensibility that family is blood family we're talking about is best.
Yeah.
But adoption also teaches contrary lessons, that family is not just about blood. Family is about what you form from love, from the security of a child, etc. And that's part of what makes this so complicated, right? Because it's not always all about blood. But when you have a treaty, when you have the Hague Convention for International Adoptions or ICWA domestically, you do have a legal document that the lawyers have to figure out and work through. My bottom line is, and I'll probably say it again and again given the opportunity, is I wish they'd worked it through a lot earlier so that this poor traumatized kid would have suffered some fewer years of trauma.
I agree with Adam on that point. And what is really important in this case is this family placement was identified before the child was ever placed with the Pages. The goal in this case was to place the child with her father. And when that no longer was available, 3 years ago, the court said, move this child to her family in Utah, and the Pages have continually fought this in court. That we often see this situation happen where we can't place a family because the child has to be located close to their parent when a parent is seeking to reunify with their child. And once that doesn't happen, as in this case, when the goal is adoption, you will often see children move, Indian children and non-Indian children move to out-of-state placement for family once reunification efforts on behalf of the state have ended.
But what you don't see, well, I just want a point of clarification, Chrissy. It's actually not true that the family was identified to the court. They may have identified themselves earlier on, but the alternative placement, the Utah placement, was not identified to the court as such until after reunification had failed.
So Laurie and Chrissy, remembering we have an international audience, so I'm
Yes.
looking at big picture here. Malika, where do you want to take us?
Back to a point that Adam raised just a little bit earlier. You talked about race and culture being a factor that is often looked into. So I want you to have a listen to this video comment we got from Scott, who is speaking to us from the United States.
So-called racial matching policies in child welfare and laws like the Indian Child Welfare Act really mean that certain children in America, because of their race, their color, their ascribed or real tribal affiliation, and like criteria, have fewer rights to be adopted, to have stable, loving homes and families than do other children in America. This is not only absurd, this is unconstitutional, this is wrong. This must stop now.
So Adam, I see your facial expression there. Lori's too.
I'll take it. We can each, I mean,
we can each have,
go.
We may
for
have
it.
very
No, you
similar
first.
reactions. I think there's just a world of difference between taking these things into consideration, race and
That's
culture, and having them be the only consideration regardless of the harm that we might do to a child. So there's a world of difference between the time when a child is in need of a placement and you have some options and you're looking at, a family X and a family Y, and sure, you're going to try to place with family or have some cultural and racial matching or what have you. I mean, these are all potentially relevant factors, but the problem that I have is that ICWA in particular, unlike other federal laws, which prohibit discrimination on the basis of those factors for children, ICWA sort of encourages, unfortunately, an initial placement and then disruptions in that placement. And I think that is, in cases like Lexi's case and other cases, it's causing harm to children without a justification that is really compelling.
So where I want to weigh in is on the identity stuff and on the race stuff, the ethnicity. It is a factor. I couldn't agree more. For a long time in this country, because of a federal law a few decades ago, it was forbidden to take race into account in child placements from foster care.
Forbidden? That's
it was
bizarre.
supposed to be, yes, I agree with you. It was supposed to be colorblind.
Wow.
Well, and over time, certainly in practice, if not in policy, people understood it is a factor. The kid is going to grow up black, even if he has white parents, and not allowing it to be a factor means that you can't do all you should do for that child. So it's no one's saying that white folks shouldn't adopt kids of color, and it is against the law to forbid that. But to be a factor so that if you do adopt, for example, a little girl who's black and you're white, well, you might want to learn how to do her hair. You might understand that.
Speaking from personal experience here.
And if you want to adopt a boy, you might want to get some education about how you tell him he may be followed by store detectives. Because you can't explain that from your experience. You can't know that from your experience. So nobody is saying, or I'm not saying, that it should be forbidden in any way or that you should have fewer opportunities. But should you be educated? Should it be a factor so that we have our eyes wide open? Absolutely.
Chrissy, I want to bring you something that someone just raised online. This is Chatan. She says that understanding that ICWA is not a race-based law is foundational to understanding the other complexities at play here that we've been discussing over the past 30 minutes or so. And she goes on to say, what you're really saying, and I think she's speaking to some of the people online, is that Native nations are less competent than states regarding children. And this is false and biased. Do you see it the way she sees it?
Absolutely. Again, I've already talked about ICWA not being based on a child's race. It's based on their tribal membership. But I have ongoing cases right now. I have appeal cases in other states where we have attempted to transfer cases into tribal court, and those who oppose the transfer to tribal court argue that the tribal courts aren't as well suited as the state courts to determine what's in the best interest of Indian children, which is, again, goes back to the reason that ICWA was passed. Tribes, more so than state courts, are in a position to determine what is best for their children. And when you think about, these opponents to the Indian Child Welfare Act, I agree with her that what they're saying is that tribes don't know what's best for their children. We, the state, we, the outsiders, we, the non-Indians, we, the non-family, we should be deciding what happens to these children. And this goes back to the history of assimilation and termination in this country and how we treated tribes. The reason that ICWA was passed, because in the 70s, state authorities didn't think that tribes could take care of their own children, and they were going in and forcibly removing them because they didn't think tribal governments could care properly for their children.
Guys, let me play you something. This is from Facebook, and it's a statement from the Page family. And I just want you to listen to the language of this statement. Have a listen.
Our daughter is just one of many victims of the Indian Child Welfare Act, a horrific law that the U.S. government continues time and time again to give absolute power to tribal leaders who judiciously abduct children at will. So
we've got daughter is a victim, horrific law, abduct children at will. This is from the Page family, and this is what they're saying. This law, which was enacted to safeguard children, is doing. Now, I hear the passion.
I understand.
I hear the pain.
Right.
But are they right?
Well, they're not lawyers for one thing, so I would let their lawyers speak to that. But no, they're speaking from anguish, they're speaking from pain and loss, and all of the things that any parent would feel in a circumstance like this. It doesn't make them experts on ICWA.
Right. And also, I mean, the other thing here is they're foster family. So as a foster family, can your foster kid be abducted from you? Are you not just a temporary guardian?
Well, actually, yes. I mean, a foster child can't be just arbitrarily removed. They're more than foster parents under state law. They have rights to challenge the removal of a child. But I think the abduction language is coming very much from the way they experience this and the way they imagine this daughter that they raised for 4.5 years must have experienced it.
See,
and they're extrapolating from their experience, right? And saying that this is what happens to all children. And we know that's not what happens to all children.
See, but let me show you something.
These are also the same people who invited the media to record the removal of this child from their home, with dozens of people outside screaming at her and taping her and putting that on the media, which was disgusting. That's not how you treat a child that you care about and love. I'm a mother, and if I knew that my child was being removed from my home, I would do everything in my power to make that transition as peaceful and as non-scary and as loving as possible. And what we see over and over in the news is a 6-year-old girl being taken out of her home, crying, people screaming at her, people taping her.
See, Chrissi, this case is not quite over yet, and I don't want to keep dragging Lexi back into the conversation, because there's a bigger point here. And does it mean that this law, is it being demonized? Is ICWA being demonized, or is it working as it should be working from your perspective?
Absolutely is working as it should be working. As you heard, this case is an anomaly. My tribe, the largest tribe in the country, has thousands of ICWA cases a year, and in 90% of those cases, the outcomes are permanent placement with family or reunification with parents or tribal placement. And we have these couple of cases that make the news, and it's always the same headline: Indian child ripped from white family. It is what we see every time that the Indian Child Welfare Act.
You make a really good point, Chrissi. The reason we talk about it is because it's an unusual case. It's not because it happens every day. One-line summary from you, because we're right at the end of the show.
Sure. I mean, I agree it's an unusual case on its facts, but I do think that there are aspects of ICWA that could be improved to improve the chance that a child could get stability and permanence earlier in the process. I think what happened here with an initial placement that was with the tribe's consent could have resulted in permanence for this child and should have resulted in permanence in for this child.
Right.
And that Congress contemplated that.
All right.
Because there's a good
Laurie,
cause exception.
Alvino, McGill, Adam Pertman, Chrissi Nimmo, good to have you here. Malika, what's the community, how they've been reacting to this conversation?
Candace says she likes this law because it reunited herself and her sister with her mother and siblings.
Okay, thank you very much for being part of this conversation. You want to continue it? Hashtag AJStream. We'll see you on Twitter. Thanks for joining us today. Take care, everybody.